Okay, well, let me pull up the presentation today and go like this. There. All right. Everybody got the slide? Awesome. Okay. So as Mary was saying, we're for the past year been doing seminars on IRA planning, and especially there was a rule that passed, the law that passed last year called the Secure Act. So really been focusing with clients on the changes that occurred from old IRA inheritance rules to new IRA inheritance rules. As we moved a year past the Secure Act, we thought we'd expand the seminar just a little bit. So what we're going to be covering today is basic estate planning, and then we're going to talk about estate taxes, again, kind of just in a basic way. And then we're going to discuss IRAs in some depth, just to discuss ways that those pass and the rules of that occur when someone inherits an IRA from you. There's going to be a lot coming, so if you have a question, please raise your hand, send a text to Mary, and she will stop me, and we will make sure that everybody's understanding what I'm going through. So, disclaimer, basically this just states that, you know, especially when you're talking estate tax planning and estate planning, always better to have a team involved. If you have an attorney, work with that attorney, bring your CPA on board, bring your financial advisor on board. If all those folks are talking, it goes a lot better. And please don't do your own estate planning. I tell my clients, I don't do my own electrical wiring, and I hire somebody who knows what they're doing on that, and I recommend the same for estate planning. My background, as you might be able to tell from my way of speaking, I'm from Tennessee originally. I'm a Washingtonian by choice, been out here about 15 years. My wife and I moved out as a result of Navy service. Went to Vanderbilt, went to University of North Carolina, Chapel Hill, so Southern born, Southern educated, joined the JAG Corps, and I've now retired for about a year. I've got 25 years total service, 9 active and the rest reserve. Spent about 9 years with the IRS as an estate tax attorney. So I was on the other side of estate taxes, and it's nice to be working on the good side of the force here, helping people along. My focus is on estate planning and some tax controversies and tax filing, but the bulk of it is estate planning, either tax-driven, not tax-driven, blended families, good old-fashioned straight-up I love you wills, just about everything I do here, but my primary focus is on estate planning. You know, you always say you're not going to marry XYZ, and I maintained I was not going to marry a lawyer, certainly was not going to marry another Navy JAG, because that would be insane, right? Well, I did both. I married a Navy JAG, and we have 2 kids, 12 and 14, and I am proud to be a partner here with the Sherrard McGonigal firm. So that's not quite accurate, but again, please don't do your own estate planning. Work with professionals to get that done. So we're going to talk about what are basic estate planning documents. What is an estate plan? You know, you hear about these things on financial management shows, and you read, there's articles in Fortune and Kiplinger's and all these other magazines, but you need an estate plan in place. At the end of the day, it's a few documents which determine who is going to manage your affairs when you can't, either because you're no longer competent to manage your affairs or because you've moved on and you've passed away and there's somebody that needs to step in and handle your final affairs. The first document everybody thinks about is a will or revocable trust. Without going into too much detail, I'll just say that Washington is a very straightforward probate state. We don't fear probate here in Washington nearly as much as you do in other states, and so the vast majority of our estate plans are done with a good old-fashioned will. Probate in Washington is straightforward. The judges really don't want to get involved unless you need them to. So it's a very simple process here in Washington, and we utilize it all the time. The other documents you sometimes don't think about are critical because they're the ones that affect you during your lifetime. A will, as you might suspect, only takes effect after you're dead. The power of attorney is who manages your affairs while you're still here. Those normally handled with 2 separate documents, a durable power of attorney for financial decisions and a durable power of attorney for healthcare decisions. Another document which is often part of an estate plan is a directive, a declaration, advanced medical directive. It's all the same thing. It's a living will. If you end up in a permanent unconscious condition or a terminal condition, that document springs to life and instructs people to remove artificial means of life support and allow you to pass a natural death. Additional documents that can come into play if we need them insurance trusts, retirement plan trusts, detailed funeral desires. And we actually provide a spot for that in our binder. If you want to write those out on your own, it's a great document for your friends and family and loved ones to have, so they're confident that what happens with your remains and what happens at your memorial service is what you wanted. And then finally, a community property agreement. Some circumstances, those can be extremely helpful as well. That's an agreement in Washington where a married couple states what property is whose, what property is ours, and then even sometimes where it goes when the first spouse dies. Planning for minors, I point this out just because it's a concern of a lot of clients of mine. Minors can't own property. So if you want to leave them stuff, how do you leave them stuff? Most of the time it's in a trust. That is the common approach. The terms of the trust for minors are typically very liberal. Common expenses, basic support, healthcare, education, vacations, enrichment events. You know, they want to take horseback riding lessons? Absolutely. Want to play lacrosse? Absolutely. Want to need a tutor? Absolutely. Paid out to the beneficiary at the ages you determine, so outright to the beneficiary at some age. You select the trustee with alternatives. Need not be the guardian, so you can select a guardian separately from who manages the money. And you can even put incentives in there. If you want them to go to college or trade school, that can be an incentive for them to get an extra amount outright of the trust, or disincentives. If the minor or child has a history of drug dependency, you can require drug testing. These trusts can be just about as flexible as you want them to be. So we're going to talk about basic estate tax concepts today. The federal estate tax right now is thankfully out of almost all of our lives. It has an $11.8 million exemption. It's a 40% tax on the amount over that. That amount's increased yearly. It includes everything basically that you can control. IRAs, 401ks, life insurance, your home, your brokerage accounts, just about anything that you can direct is going to be in your estate. Now, the federal estate tax is interesting because with the change of administration that we had a few weeks ago and the change of control of Congress, it's likely that we're going to see a reduction of that $11.8 million to some level. Could come down as far as to $3.5 million. So still a big number, but a lot smaller than 11.8. And so in getting closer to the Washington exemption, as we'll talk about here in a second. If you hear about a $15,000 or a $10,000 a year exclusion on gifts and you're told that it's income over that, people get this kind of all mixed up all the time. Basically, the $15,000 per year means you can give anybody $15,000 and not use a single part of your federal credit. If you go over $15,000, you use some of your federal credit for the amount over $15,000. Gifts are almost never income. They're just gifts. And so that $10,000 is not a point where it becomes income. It's just a point of where you start using your credit. Most of my clients are much more concerned about the Washington estate tax. It kicks in at just under $2.2 million. And again, it includes everything that you can control. IRAs, 401ks, life insurance, your home, brokerage, the whole kit and caboodle. Washington does not have a gift tax. So everything you give away during life doesn't count towards the $2.193 million. It's what you die with at death, pretty much. The exemption is likely fixed under current law until 2025. But again, with the change in Washington, we could see that $2.193 million start creeping back up again, which would be a good thing. But it's been fixed there for 3 years now because of some provisions of the 2017 Federal Tax Act, which caused it to freeze. So Washington estate tax is the highest in the country when you compare the exemption and the rate. It starts at 10% after 2.2 million, and that bumps all the way up to 20%. So it can be a pretty onerous tax if your estate is above 2.2 million. So simple estate planning. We need tax planning. In the back of your mind, be thinking for federal exemption, probably $2 to $4 million, because even though it's 11.8 right now, it's likely going to be coming back down. And as we figure out what this new exemption is going to be, it's going to be more important to be on top of this. So, you know, your age, your health, the investment mix you've got, the family composition. Are you a blended family? Are you not a blended family? Are you single? Are you married? All play a role as to when you need to start taking into account of the federal estate tax. And that's where working with an estate planner is really helpful to determine what you need to be planning for. Washington as tax planning, I kicked that in at probably about $1 million. And again, that's a big number, but if you own your home and have a retirement account and a life insurance policy, in most cases, you're close enough or you're over $1 million of your total estate pretty quickly. Washington, no gift tax. So if we give things away that you don't need for your own well-being, then we can limit the Washington estate tax through those lifetime gifts. So 1 million, you need to start thinking about the Washington estate tax because you're getting close to it. Federal, probably 2 to 4. Can anything be deducted? Yes. The debts you pass with are taken off of your estate for tax purposes. All these expenses of administration taken off for tax purposes. The biggest two that I work with, though, is the marital deduction. Items left to a spouse are entitled to a 100% deduction. So if Bill and Melinda Gates have no tax plan and Bill Gates were to pass on and leave all $70 quadrillion he's got to Melinda or vice versa, there's no estate tax upon that first passing. Where we're concerned about is that second spouse that passes that isn't married at the time, and they can be exposed to estate tax. We can use marital trust and credit shelter trusts to plan around that, which we'll talk about here in a second. The second big deduction my clients use is the charitable deduction. Items left to a charity out of your estate also get deducted from the total, and that's a 100% deduction as well. So as you can see, public policy likes marriage and likes charities. Everything else is kind of iffy on deductions, but those two are certain, and those can be an important part of an estate plan to try and reduce taxes and make sure that what you want to have happen happens. So what is a credit shelter trust? Basically, it's the most basic estate tax planning structure that you can put in place. It holds property after the death of the spouse, usually is when you're going to use it. Now, the terms are pretty liberal. The income is almost always available to the surviving spouse, so all the income from the trust flows to the surviving spouse. The principal of the trust is available for the spouse's maintenance, education, health, and support. That's a long list of things. It basically means your health care is covered. You can cover that out of this trust if you want to, and you get to maintain the lifestyle you had when that first spouse passed. The beautiful thing about a credit shelter trust is you use the credit of the first spouse to make it non-taxable. So in Washington, you could put up to $2.193 million in that credit shelter trust. And because it was used the credit of the first spouse to die, it's not in the estate of the second. So we'll talk about an example here in a second, but in Washington, you can shelter up to $4.4 million doing that way, because it's $2.2 million on the first spouse and $2.2 million on the second without paying any estate tax. Talk about a one lung trust, because we use those quite often in our practice here. It combines a marital trust with a credit shelter trust, leaves a lot of options open for the surviving spouse to make decisions upon the death of the first spouse as to how they want to treat that trust. Normally we can treat the trust differently for Washington and federal purposes. So all this uncertainty at the federal level doesn't affect us nearly as much because we're extremely flexible with that trust, and we can adapt to the law as it exists when that first spouse passes on. We can either fund it with a pecuniary amount, meaning a certain amount. I leave X dollars to the credit shelter trust, or I leave the maximum amount which can pass free of Washington estate tax to the credit shelter trust. Or we can take an approach of I leave everything to my spouse, but if my spouse executes what's called a qualified disclaimer, then that amount goes over to the credit shelter trust. So as you can see, estate tax planning, it's a little complex, but if we draft it properly, it's extremely flexible, and it leaves a lot of decisions to be made after the first spouse passes. Frankly, estate planning for single individuals is a bit trickier. Normally we'll take advantage of charitable deductions as opposed to a marital deduction, certainly, to try and minimize estate taxes there. I apologize because, okay, sorry, this is a bit out of order. Again, this is the first time we've gone through this presentation, so I apologize. There's a slide here out of order that I'll come back to. So all this is to say that the typical estate plan you'll see with people, especially if it's been done in the past, it's been done many years back when a married couple was a young married couple and they simply put a will in place. It's what we would call an I love you will. Everything from the decedent flows to the surviving spouse ends up owning everything. And that's a perfectly valid will. It's a perfectly valid estate plan. It's going to be honored by the court. It's just not that efficient when it comes to estate taxes. Danger of the I love you will. Well, if everything goes to the second spouse and then everything to the children on the second to die, the problem is that the surviving spouse ends up owning everything. So let's say that a couple has $3 million in assets. Upon the first death, everything passes to the surviving spouse. As I said, no estate tax, 100% deduction over to the surviving spouse. It's the marital deduction. The deceased spouse, you can make a portability election, so the feds will let you use credit if you don't use it upon the first death, but Washington doesn't. It's a use it or lose it state. So if you don't use the credit when the first spouse dies, it's gone. So what happens at that second death? Well, the second spouse federal credit, they may have used that big federal credit, so probably no federal estate tax done. The problem is now in our example, they've only got the $2.193 million Washington credit. And so that results in about $80,000 in Washington estate tax because that second spouse dies with about $800,000 over the $2.2 million limit. Whereas, as I explained, if we use that first spouse's credit, we could have passed up to 4.4 and there'd be no estate tax. So this is the danger of the I love you will with the Washington estate tax is that you can end up owing a bit upon the second spouse to pass. So estate tax takeaways for this portion of the presentation. Simple planning can allow a couple right now to pass over $22 million federally. It's a huge number. So really the federal estate tax hits almost nobody. $4.4 million Washington tax-free. Now keep in mind that the federal credit is likely to decrease. How far it's going to decrease is anyone's guess at this point. Possible fix for failing to file for federal purposes, we can do that portability election. We can file an estate tax return when the first spouse dies, even with an I love you will, and that surviving spouse gets to take that federal credit with them. It's called a portability election. So you can use it when you die as opposed to using it when the first spouse dies. That doesn't exist in Washington. So we have to use the credit when the first spouse dies or we lose it. So it's important to review your assets and your overall estate plan with a planning professional and incorporate marital deduction for married folks, credit shelter planning for married folks, and charitable deductions for single folks as part of your plan to try and keep estate taxes as low as possible. And I'm going to stop here and see if there are questions on the estate tax. Mary's almost always got a question, so, but none today. All right. Well, that said, then we're going to dive right into IRAs and the rules about their inheritance and how to leave them properly in your estate as well. So there's the only IRA cartoon I could find is this one. I think it's kind of funny though. So let me jump back up here, and again, I apologize. Individual retirement accounts have become a significant estate planning piece for more and more clients. When I first joined the IRS way back in 1999, I would have multi-million-dollar estates I'd be auditing, and an IRA would be in there, and it would be $50,000, maybe $70,000. So a lot of money, but a really small percentage of these large estates were in IRAs. Well, as people have funded them more and more, and people have rolled IRAs over into them, and we're entering a phase where we're really going to be dependent upon defined contribution plans for retirement, IRAs have taken off in value. So in 2015, there was $24.7 trillion in retirement plans, and that's doubled since 2000. So as the generation that depended on pensions is starting to pass away, and this next generation is coming on board their retirement years, we're seeing a shift. These retirement accounts are exploding in value. And IRAs now account for $7.6 trillion of that amount, and that's doubled since 2007. So IRAs are a bigger and bigger part of everyone's estate plan. Biggest takeaway today in IRAs, they do not pass under your will or trust. IRAs pass per beneficiary designation with your IRA custodian. So if you haven't looked at that form in a while, maybe you don't remember how you filled it out, it's been so many years ago, for goodness sakes, call your IRA custodian, your stockbroker, the bank, whoever you've got your IRA with, and review that beneficiary designation, because things could have changed and your desires could have changed. And no matter who you name in your will, that IRA beneficiary designation will control. So generally, IRAs passed to the beneficiaries without being subject to estate creditors, which is a good thing. So if you've got the beneficiary designations in place, those IRA accounts are generally going to make their way to the people you designated, regardless of the creditors of your estate. They are, remember, included in your estate for estate tax purposes. So there may be taxes due, but otherwise they'll be free of claims. So I'm going to jump ahead to the next. All right, so I've just talked about having beneficiaries in place with IRAs. Well, what are permissible designated beneficiaries? People. Just be thinking people. You need honest to goodness folks that you've named as beneficiaries of your IRA. There are certain trusts that we'll talk about briefly that can accept your IRA, but by and large, you don't want to name your estate or just a simple revocable living trust as your beneficiary. There can be some pretty substantial income tax ramifications to that because the IRA will have to pay out a lot faster. And if it's a traditional, that means income comes out a lot faster. So what are non-permissible designated beneficiaries? Well, estates. Again, you almost never want your IRA payable to your estate. And that's the way a lot of these get set up, unfortunately. So again, a reason to review your beneficiary designations and make sure they're in place the way you want them. Charities are officially non-permissible designated beneficiaries in that they're not recognized for purposes of how fast the IRA has to pay out. But charities can be fantastic beneficiaries of traditional IRAs. Why? Because they get dollar for dollar what's in that IRA. If someone else got it, it would be income. It's income to the charity, but they don't pay income tax. So you get a chance to leave the full force of your IRA to a charity if you've got a charitable part of your plan. And then most trusts you don't want to name as a beneficiary of an IRA. So the old rules, and these are applicable to IRAs that maybe you have that you inherited from a parent, or maybe one that you inherited from a predeceased spouse. The general rules were the IRA passing to a spouse can be rolled over to the spouse's IRA, and the spouse is the new owner for RMD purposes. RMD stands for Required Minimum Distribution. It's that amount that you have to take out of an IRA each year after you hit 70.5 under the old rules, and as we'll see, 72 under the new rules. So the spouse is the owner, and the age rules still apply. At 59.5, you can draw from an IRA, and under the old rules, at 70.5, you had to start drawing from an IRA. An IRA passing to a non-spouse is an inherited IRA, and under the old rules, the beneficiary, regardless of their age, had to start drawing from the IRA the year after the person died that they inherited it from, and it was based upon that beneficiary's life expectancy. It was called a stretch IRA by brokers as a result, because if you left it to a young individual, they could stretch those payments out over the rest of their lives and really slow down the payout. Doesn't pass to a designated beneficiary, then it either pays out in 5 years if the person wasn't drawing from the IRA when they died, or the person's RMD schedule if you didn't name a proper beneficiary to it. So if someone is 80 years old and they left an IRA that ultimately made its way to a 20-year-old and it didn't do it in the proper manner, that 20-year-old would be stuck with that 80-year-old's RMD schedule much quicker. Same basic rule for Roth IRAs, except we always assume that the owner died prior to 59.5, which means that Roths pay out in that 5-year payout period if you don't have a designated beneficiary. Well, then the Secure Act hit, and it changed everything when it comes to IRA inheritance. The good news was it raised that required minimum distribution age to 72 if you weren't yet 70.5 at the beginning of last year. So another 1.5 years that you can leave items in an IRA before you have to start withdrawing. And the other good news is that you can contribute to an IRA after 70 and a half if you're still earning income. So think wages, salaries are earned income. So if you continue to work into your 70s, you can continue to contribute to your IRA now. That was a substantial change. The spousal rules for inheritance are still in effect. So if you inherit an IRA from a spouse, you just roll it into your own IRA. And for the purposes of that IRA, it's as if your spouse never existed. It's yours. Your age determines when it comes out, and the whole kit and caboodle. The key takeaway from the Secure Act was the loss of the stretch. Now, in most cases, for non-spouses, IRAs have to pay out within 10 years of the death of the original IRA owner. So if you've got someone in their 30s or 40s that inherits an IRA, instead of being able to take it out over 35 or 40 years, now they have to take it out over 10 years. So it was a substantial acceleration. Why did they do it? They needed the money. That was a way to raise income taxes to pay for some other stuff in the bill, and so they took away the stretch to do that. There are some exceptions to the 10-year rule. They're called eligible designated beneficiaries, a new acronym to learn, EDBs. Biggest one is surviving spouses. We would use that on a limited basis because normally, as you remember, the surviving spouse can just roll it into their own IRA. Individuals less than 10 years younger, they put that in their figure, and if you leave it to your brother or sister and he or she is 3 years younger than you are, they can use their own age because it's not really that much of a slowdown. The next two are huge because that allows an IRA to pass to a special needs trust and use the life expectancy of the chronically ill or disabled individual to determine how fast that IRA pays out even into the trust. And then another exception, if you leave it to a minor, they can slow down their withdrawal until they hit 18, and then they get the 10 years at that point to take it over. How about Roth IRAs? Well, Roth IRAs are awesome. So what I would mention there is that a way to kind of lessen the impact of the Secure Act, and also a really nice planning tool for long-term care between a couple, is if you do a slow roll IRA conversion or Roth conversion. So each year, working with your tax advisor and your financial advisor, you convert a little bit of a traditional IRA over to a Roth IRA. Why would you do that? Well, two reasons that come immediately to mind. One, down the road, if you need to liquidate that IRA for Medicaid planning, the spouse that owns the IRA is the one that's going to be going into long-term care, and we need to draw their assets down. If it's a Roth IRA, you can pay it out, transfer it to the surviving spouse, and you don't have a huge income tax bill. If it's not a Roth IRA, then you can end up with a relatively large amount due in taxes all at once before it gets over to the surviving spouse. So it's a nice Medicaid planning tool as well. The other benefit of a Roth IRA, if it pays to a beneficiary and they have to take it out in 10 years, at least when they take it out, if it's a Roth, it's not income to them. You've already paid the taxes for them years before. So from an estate planning point of view, it's also a nice tool. So definitely work with your financial advisor and your tax advisor, because most of the time what they're going to tell you to do is let's compute your income taxes, figure out how far you're below the high point of the marginal rate you're at, and they'll have you do a Roth conversion right up to that next rate. So if you're at a 22% tax rate and you have $10,000 before you trigger the 24% tax rate, they might have you take a $10,000, do a Roth conversion of that amount just to get right up to the threshold of that without increasing your tax rate. So I said we don't use trusts with IRAs, and that's generally true because trusts are not designated beneficiaries, and we're going to be stuck with either the decedent's RMD schedule or the 5-year rule. I will say there's a potential estate planning tool in this after someone dies, and that in certain cases it might be worthwhile to use the decedent's RMD schedule if it was more than 10 years. So another reason why, if you are inheriting an IRA or you've got an estate with an IRA in it, it's important to be working with the team there as well to make sure that you're taking advantage of all the opportunities there. However, specifically drafted trusts can allow you to look through the trust. We disregard the trust, we look at the beneficiaries, and we base the IRA payout on the beneficiaries. So it's useful for a credit shelter amount, also very useful for special needs trusts. The first one we'll talk about is a conduit trust. That is something that, as an RMD is paid out of the IRA, as that required minimum distribution hits the trust automatically sends that out to the beneficiary. So it's just a conduit. The income hits and the income flows out. It's very flexible. You can use these if they're drafted to receive an IRA. You can look at the ultimate beneficiary and it pays out according to that ultimate beneficiary. And they can be the trustee. So when would we use these? We would use these potentially for a marital conduit trust. Remember, surviving spouses are an exception to that 10-year rule. We can use their life expectancy. So let's say we've got that $3 million estate we talked about earlier, but oh my gosh, $2.5 million of it is in an IRA that one of the spouses has. So if we have that credit shelter trust thing set up, we're not going to be able to move enough over into the trust necessarily to take advantage of that first spouse's credit, because the IRA typically will just pass directly to the surviving spouse. We can't use that credit shelter trust on it. One way we can get around that is to put a portion of the IRA into one of these marital conduit trusts. So that's there for the surviving spouse, just like a credit shelter trust. Surviving spouse gets all the RMDs, just like a credit shelter trust, all the income, but it's use the credit of the first spouse to protect it, and it's not in the estate of the second spouse. So we need a little bit of IRS clarification on how exactly this works after the Secure Act, but we can still generally use them if we need to. This would be used when you've got an estate which is potentially taxable and it's really heavy in IRAs. So we can't move enough other stuff around to take advantage of that first spouse's credit. I'll talk briefly about accumulation trusts. The most common use after the Secure Act are for special needs trust or supplemental needs trusts. These are Social Security or Medicaid planning trusts. You've got someone who is chronically ill or disabled, who is eligible for either Medicaid or Social Security or both. You want to leave them assets, but you don't want to knock them out of qualification. You use a special needs trust to do that. And because of the exception, remember, to that 10-year payout, if we have someone who's chronically ill or disabled, we can set up a special needs trust for them, have the IRA pay into it, and that IRA will pay out according to the life expectancy of the person who is chronically ill or disabled per the Internal Revenue Code. It offers superior creditor protection if you want to use it even for someone who is not disabled. We're subject to the 10-year rule, but at least they can't get to it. What an accumulation trust means is that the RMD hits the trust, and then the trustee has complete discretion where that RMD goes. It can stay in the trust, and the trust can pay the income taxes, or he or she can pass it out to the beneficiaries. The downside to leaving income in a trust, as you can see from that last bullet, is that trusts pay the highest marginal rate, 37%, at just under $13,000 worth of income. So whereas it takes an individual several $100,000 of income to get up to that top marginal rate, trusts get there really quick. So again, for accumulation trusts, the most important use post-secure is almost certainly in supplemental needs trusts and special needs trusts for folks who are otherwise qualified for Social Security or Medicaid or both, to avoid knocking them out of qualifications. So remember, I told you that IRAs are excellent charitable giving vehicles. Well, they are traditional IRAs. So I'll give you an example here. Let's say that you've got $1 million IRA and $1 million in other assets, and you would like for your estate to go half to a charity, half to your kids. Well, the way this would traditionally be done is the IRA would most likely be left to the kids, because that's just the way that financial advisors and attorneys are going to tell you to do that, is, you know, if you try to leave it to kids if you can. So most of them are going to be set up to go to kids. And then your will is going to leave everything else, 50% to your kids, 50% to charity. Two things there. One, half your estate didn't go to charity because your kids got all the IRA and half of your other stuff. That may be okay, maybe not, but it doesn't sound like your intent in this case. The other problem is your kids got your traditional IRAs, so as they receive those benefits from the IRAs, they're taxable. They got to pay income tax on them. So what's a better go around? Take a look at your whole estate and figure out, okay, I got $2 million. If I leave the IRAs to the charity, then that takes care of giving half of my estate to a charity. Done. And the charity gets the entire $1 million. They don't have to pay income taxes. My kids get everything under my will. They don't have to pay income tax on my house or my brokerage accounts. So it allows for both portions of your estate to receive the maximum amount possible with the minimum amount of income tax. So just something to keep in mind. If you've got a charitable bent and you've got a traditional IRA, that's a great way to leave money to charity. I do want to mention qualified charitable distributions. It turns out it's likely that this year, unlike last year, we're not going to have that RMD holiday we had. You didn't have to take anything out of an IRA in 2020 as part of the CARES Act, that first COVID relief bill that got passed. Likely in 2021, I haven't heard any inklings from Congress. They intend to continue that. So you likely will have to take things out of your IRA. Definitely stay in contact with your financial advisor because they're going to be up to the minute on those issues. But let's say that you've got an RMD you don't want, you don't need, and you would instead like for it to go to charity. Well, two ways to do that. One is you just take the RMD, it's included in your income, and then you give it to the charity that you want to give it to, and you may or may not get the deduction for that. If all of your deductions fall below the standard deduction, it doesn't affect your taxes at all. It just raised your gross income up a bit. One way around this is the qualified charitable distribution. As opposed to taking the money from the IRA and then giving it to the charity, you just tell your IRA custodian to give the money directly to the charity. And that way it never hits your income tax return at all. And it allows the charity to receive the full force and effect of the RMD. So it's just not part of your gross income, doesn't raise your taxes, and you get the full benefit of the deduction. Just a couple of final points on IRAs, other planning tips. Durable powers of attorney that we have in place for someone to take care of us when we no longer can. So it's one of that big 4 list of estate planning documents I mentioned at the beginning. It is important from an IRA perspective to have detailed powers in your power of attorney dealing with IRAs. It's not enough anymore to give your attorney, in fact, general power over my financial accounts or power to affect all my banking. That used to be enough. IRA custodians would accept that and allow your attorney, in fact, to make changes on your IRA. They won't let that happen anymore unless you specifically give your attorney, in fact, the power to change beneficiaries and otherwise move your IRAs around. Why would that be important? Well, I'll give you a case study. I was called in to help out another attorney in a estate they were managing. The first spouse had passed. They were managing the estate of the second spouse at the time. There was an IRA the first spouse had passed, had. It passed to the surviving spouse, exactly the way good planning will have it go. And that surviving spouse then had rolled it over into their own IRA, everything done perfectly. The problem was the second spouse was no longer competent and their child was working as their attorney in fact. They went to the IRA custodian and said, hey, on this new account, I need to list myself and all the rest of my brothers and sisters as beneficiaries of this. This is the way my parents have always had it set up. Everything perfectly appropriate, above board, trying to do the right thing. Because the power of attorney for that second spouse did not have specific IRA powers in it, the IRA custodian told them no, that it's going to pass to the estate of your parent, and then you're going to be locked into their RMD schedule because there aren't beneficiaries designated. We were able to fix that with a court order, but it was time consuming, it was expensive. And so older powers of attorney oftentimes will have this problem. It's important that you update your documents to make sure that the powers that you grant over your IRAs are what you want. It gives your attorney, in fact, a lot of flexibility. So we're at the end of the presentation. I'll stop here and see if there are any questions. If anything popped up, there's been a lot we've discussed today. So if anything is unclear, I'd be more than happy to go back through it.
There's none in the chat menu, but people are welcome to unmute at this point, and if the presentation part is over, let's take off the share screen.
Will do. Let's see here. There. Like it never happened.
And I can stop recording too.
Okay.